I want the whole country to look at this, because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it, and if you go off on a wild goose chase, another tangent, you start reading statistics, or you start talking about stuff going on in our district, and by the way, I invite you to my district. Come to my district, but that's not what we're here to do today, okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice.
Congressman Jamie Raskin didn't walk into that hearing to trade sound bites. He walked in with a paper trail that, if his argument holds, raises a far bigger question about power, money, and who the Justice Department is really protecting. We're talking about a $10 billion claim against the IRS, a number so massive Raskin framed it as brushing up against nearly 80% of the agency's yearly budget. And the deeper he went, the worse it looked. Because this wasn't just another political clash. This was a confrontation over whether a sitting president can use the machinery of government to pressure, defend, or even potentially enrich himself through agencies that ultimately answer to him. Then Raskin brought the Constitution into it, not as a prop, as a direct challenge. And when Attorney General Pam Bondi answered with what sounded more like a personal dismissal than a legal defense, the entire exchange changed tone. Stay until the end, because the moment Bondi is told she does not get to keep talking over the rules is the kind of hearing room shutdown that says everything about how tense this really became. And if the Department of Justice is starting to look less like an independent institution and more like a private shield for executive power, then yes, the receipts matter.
Thank you, Mr. Chairman. I want to start by saying I appreciate what you said, Attorney General Bondi, and you said it to me personally, that you take the personal security of every member of Congress seriously, and that people can contact you about that. And in these times, that's a very serious matter. So I thank you for that. Article 2, Section 1, Clause 7 of the Constitution is the domestic emoluments clause. And it says that the president is limited to his salary in office and cannot receive any other money from the federal government while he's in office. It cannot be increased by $1. This president is the first president in U.S. history who has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn, but he wants $10 billion. Now, well, I want to ask you the question of whether you think it would violate the domestic emoluments clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the domestic emoluments clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation.
Okay, so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
With obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time
Mulligan will be
restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this. Because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question and you answer it, and if you go off on a wild goose chase, another tangent, you start reading statistics, or you start talking about stuff going on in our district. And by the way, I invite you to my district. Come to my district, but that's not what we're here to do today, okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule at this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms and committed sextortion. Yet he didn't even know in your tiny little district who he was.
Mr. Chairman, she's embarrassing you.
He's about to be
This is your committee, and she is embarrassing you.
Shame on you.
The time of the gentleman has expired.
Raskin doesn't build these moments around cheap gotcha lines. He builds them around the record. This time, the record started with the Constitution itself. He pointed to Article 2, Section 1, Clause 7, the Domestic Emoluments Clause, and used it as the foundation for a much bigger argument, that a president is entitled to a salary, but not some open-ended financial arrangement with the federal government while in office. Then came the number that gave the exchange its weight, a $10 billion lawsuit against the IRS. Raskin's point was not just that the figure was enormous. It was that the structure of it, as he presented it, raised a stunning question. If the executive branch is involved on both sides of the equation, who is actually protecting the public interest? That is where the hearing stopped feeling abstract. Because what Raskin was really doing was challenging the idea that power can supervise itself and still call that accountability. And then he shifted from billions on paper to people in actual danger. That is where the room got harder to ignore. Raskin contrasted the president's claimed damages with the consequences faced by Epstein survivors after private information was reportedly exposed, including names, phone numbers, and home addresses that were supposed to remain protected. And suddenly the moral contrast became brutal. If embarrassment and disclosure are being treated as catastrophic when they affect the powerful, what is the value of safety, privacy, and basic protection when the victims are ordinary people? That was the pressure point. That was the question hanging over the room. And instead of directly resolving it, Bondi appeared to pivot into attacking Raskin personally, suggesting obsession rather than addressing the substance of what he had laid out. But Raskin wasn't done. He brought up Chase Mulligan, a criminal case in Bondi's own district that, by his framing, she seemed far less prepared to address. And that contrast landed hard. Because when an attorney general appears more engaged with defending the political priorities of the president than answering difficult questions about crime, victims, and equal justice, people stop hearing law enforcement and start hearing selective enforcement. That is the bigger danger in exchanges like this. Not just one awkward hearing clip, not just one combative answer, but the impression that transparency becomes optional when it threatens the powerful, and urgency only seems to exist when elite interests are on the line. That is why this moment mattered. When Raskin told Bondi, in effect, that she did not get to overrun the rules, it was about more than procedure. It was a line being drawn against a theory of government where loyalty outruns law and public institutions start behaving like private defense teams. The principle underneath all of this is simple. Accountability cannot survive inside closed-door logic, insider deals, and power protecting itself. Whether the issue is a multi-billion-dollar claim involving the federal government or the exposure of vulnerable victims, the public is left asking the same question: who is justice actually for? Drop your thoughts below. Should any president be in a position to effectively negotiate with an apparatus that answers to his own branch? And after this performance, does Pam Bondi look like an independent guardian of the law, or something else entirely?